Hi, very good morning. Uh, this is a very good judgment, beneficial judgment to the registered dealers. Hence, I am sharing this judgment with all of you. The Kerala High Court, Yum Trade Links versus Union of India. There were many writ petitioners. I am just giving the name of the first writ petitioner. In this writ petition, the constitutional validity of Section 16(2)(c) and Section 16(4) of GST Act was challenged. The finance guys or the tax guys will know what is section 16(2)(c) and what is section 16(4), but the law, all the lawyers, because now the field has become like a doctor's profession. People are concentrating only in a particular law, or the businessman may not know the entire law. So I'm just giving the gist of what is 16(2)(c) and what is section 16(4). Section 16(2)(c) of the GST Act says it restricts the input tax credit by the purchasing dealer to the extent of tax paid against the supply of goods or services by the supplier. So, if the supplier has not remitted the tax to the government, then the purchaser will not get the credit of the same. For example, suppose if somebody is, you are buying goods from somebody, 100 rupees is the value of the goods and 18 rupees is the tax component. Then 118 rupees he will invoice, you will pay 180 rupees. Then 18 rupees credit you will get, you can adjust against your future sale. This 18 rupees tax, the supplier who has collected from you, he must pay it to the central government and the state government. If he is not paying that tax, then you will not, the purchaser will not get the credit. That is the idea. Similarly, Section 16(4). Section 16(4) prescribes a time limit within which the input tax credit should be taken. So, if you don't take that credit within a particular time limit, then you are missing the bus or the train. You won't be able to avail. It runs to several crores of rupees. These two provisions of GST were challenged as unconstitutional before the Kerala High Court. And these types of cases are pending before several high courts. Normally, when a provision is challenged as unconstitutional, the courts generally will not be inclined to accept the unconstitutionality of the provision, especially in the case of taxing statutes. Mostly, all the cases will fail. In some cases where the courts finds it difficult, then they will read down the provision. And only in a few cases where they find this unconstitutionality, my God, is writ large on the face of it, then they will struck down the provision. Otherwise, they will preserve the constitutionality of this of the provisions. Then, getting into the case, in this case also, Kerala High Court held that the provisions, that is Section 16(2)(c) and 16(4) are constitutional. I am not going to give the reasoning of this court. Simply put, they said no, no, it is not acceptable. These two provisions are valid, and it is within the parameters of the constitution. That is what they said. Kerala High Court held that the claim of ITC is in the nature of a concession or entitlement. It is not an absolute right. The credit which you are claiming is not an absolute right. It is subject to terms and conditions and time limit also. Section 16(1), that is a section which grants the registered dealers to take the credit charge on the supply of goods or services. The submission that section 16(2) cannot take away the right granted under section 16(1) was not accepted by the court. It said no, no, the restriction is valid and it is correct. The court, after analyzing the provisions of GST, held that the scheme of GST provides that the tax collected and paid to the government can only be taken as credit. That is, if your supplier is collecting the tax and is not paying it to the government, then you can be denied. The purchaser can be denied the credit. If government has not received the tax, naturally the purchaser will not get it. Under the GST laws, the tax collected has to be assigned to different jurisdictions where consumption takes place, because it is a consumption based tax. So the goods might have started this journey from Kashmir, and it would have reached Kanyakumari. From one state to another state, sale would have happened. So finally, the consuming state will have to get the tax collected. But if the supplier has not paid, how the government will transfer it? That is a problem. So they say in case where a supplier defaults in payment of tax and the purchaser is allowed to take credit based on the invoice, the originating state government has to transfer the tax amount which it never received, causing loss to the exchequer to the several crores of rupees. This will make the whole GST law unworkable. Hence, the court held that the conditions prescribed are not unconstitutional. Further, the Kerala High Court held the conditions, restrictions, and time limit and the manner of availing ITC is a self-monitoring and self-policing provision. So you are yourself doing everything. It is not the government interfering in anything. It is a self-monitoring provision and self-policing provision also. So if the purchasing dealer wants to claim the ITC, that person has a reason and he has an incentive to request the documentation and tax payment compliance from the seller to ensure the chain is not broken. So suppose if you have paid the tax in the invoice, then you should ask the selling dealer to have you submitted your return, give me the details. Where is that return? Now that the GST or 2A is available. So whatever method you want to adopt, you can ask for proof of payment of tax to claim the credit. That is what the court says. As far as the time limit is concerned, the High Court held that it is not a new phenomenon. Naturally, those who are in tax experts, they will know this was there in the VAT system also and in the SENVAT credit system also. Sales tax VAT and SENVAT credit. Section 16.2 restricts eligibility of ITC and Section 16.4 restricts the time limit, which we have seen. The High Court rejected the submission. Once the condition under Section 16.2 is met, the time limit under Section 16.4 is arbitrary. That they did not accept. You have to abide by the terms and conditions of 16.2 and also the time limit provided under Section 16.4. The court noted that the government, considering the difficulties experienced by the registered dealers, in the earlier years, 2017 it was introduced, so they issued a circular extending the time limit for claiming ITC for 2017-18 and 18-19. Court permitted the writ petitioners who were before that court, Kerala High Court, who could not avail the benefit of the circular, to avail the same within 1 month from the date of the judgment. They said, okay, I am giving you 1 month time, go there and avail the benefit. Prior to amendment of Section 39 by Finance Act 2022, I am sorry, this will be slightly, I don't want to explain this. So you must know this, otherwise you just forget this, understand the balance point. The date of furnishing of return was 30th September. So one return has to be furnished. It is 30th September. By the Finance Act 2022, considering the difficulties, time limit was extended from 30th September to November 30th of the succeeding financial year. According to the High Court, the amendment is only procedural in nature and this must be given retrospective effect. So hence the court, the Kerala High Court extended this benefit for all the taxpayers because government extended it only for the Kerala High Court extended this benefit for all the taxpayers for the period 1/7/2017 to 30/11/2022 when this amendment was made. So for the entire period, for the 5 years, it has extended. The court directed the department to extend the benefit in case if a dealer has filed a return after 30th September, which was the date prescribed for filing the return before the amendment. And it permitted the registered dealers to claim the ITC if it is made before 30th November. The court directed the department to grant the ITC benefit because the amendment, according to the court, is procedural in nature. Now, this is the view of the Kerala High Court. We need to see since writ petitions are pending before the other high courts, whether the same benefit will be extended by the other high courts also based on the Kerala High Court judgment. That we need to see. Thank you very much. It's a beneficial judgment, so people can make use of it. Have a great day. Thank you.